Welcome to the Estate Blueprint, Planning Your Future with Tom Begley.
Hello and welcome back to the Estate Blueprint with attorney Thomas D. Begley III, founder of Thomas D. Begley III, LLC in Moorestown, New Jersey. Tom is a certified elder law attorney with more than 35 years of experience helping South Jersey families protect what they've worked for through estate planning, special needs trusts, Medicaid planning, and probate administration. I'm Kevin Rosenquist, and today we're talking about non-probate assets. Understanding how they work can prevent costly mix-ups and family disputes later on. Tom, good to see you.
Good to see you again, Kevin.
So what does the term non-probate asset actually mean, and how is it different from property that goes through probate?
So a lot of people have an impression that anything that they own will pass through somebody's will. And a lot of times that is the case, like if you're single and you own a house and bank accounts, or even if you're married but their property is just in your name. But there are three types of assets that typically will pass outside of probate. The most common one is jointly owned property. So, like, for example, if you and I would own a piece of real estate together and it says Tom and Kevin, joint tenants with a right of survivorship, when I die, it automatically goes to you or vice versa. And that also applies not just to real estate, but oftentimes with bank accounts. The second type, which is the biggest, is what I call contract assets. And they fall into four categories. The first are IRAs. The second are other forms of retirement plans. The third are annuities. And the fourth is life insurance. Those assets all have beneficiary designations on them. So I can have a will that says, for example, that, my daughter Lauren is going to be the beneficiary of my annuities. However, if my beneficiary is actually Marie, my other daughter, or Amanda, my other two daughters, under the designation from the insurance company that provided me with the annuity, then they're going to get it and Lauren's getting nothing. So a lot of times people think it automatically goes through, but it goes to whoever it's named. And the other type is not so big. Well, it's becoming big in some states. Fortunately, not New Jersey. It's called POD or TOD. That's paid on death or transfer on death. Paid on death is the accounts we've had since we're kids, where it just means that somebody set up a couple of bucks in the bank for typically like a kid or a grandchild, most likely, and the idea that if they passed on, the child would get a little bit of money. In a lot of states where probate's really intense, like Florida or California, most people who are responsible get revocable living trust, but there are a number of financial institutions that will recommend that you can bypass that by having what's called a transfer on death designation, which works the same way.
So then if an account has a named beneficiary or is set up as joint ownership, does the will have any control over that asset at all?
Nope, not at all.
Okay. And
that's a problem at times.
Yeah. What kind of problems does that typically cause?
Okay. Well, as far as the problems are particularly that it would cause is that a lot of people have an understanding or an assumption that everything's going to go through the will. So I've seen cases, for example, let's say with joint assets. Mom's widowed, she has 4 children, and she wants to treat all of them equally when she passes away. But as she gets older, she has one of her adult children help her as far as managing the estate or the assets are concerned. The problem is, instead of the bank taking the power of attorney, they'll have the child added on as joint owner to the account. Now, fortunately, 95% of the time, what will occur is the individual will be nice when they get the money from mom when she dies and turn around and spread it out among his or her siblings. But there's enough occasions where it hasn't happened. And I've been involved in a couple court cases where one in particular, and everybody knew in their heart of hearts what dad wanted. But in essence, basically, there were 2 daughters who were supposed to get everything 50-50. But one of them actually got an extra account worth about $500,000 just because rather than using the power of attorney, dad just added his daughter hoping that she would do the right thing. Sometimes the beneficiary designations don't make a lot of sense. The biggest one that I encounter is issues involving minor children. So, if you have mom and dad have a couple of kids that are, 16 and 14 years old or 8 and 10, they often will name each other as the beneficiary of their retirement plans and their insurance. And certainly it's not a big deal. One of them dies, it goes to the other. With something happens to both of them, young kids don't know how to handle money like that.
Sure.
Typically, they're not allowed to handle it from the insurance company. So the insurance company retains it or gets paid into the local probate court in New Jersey, the surrogate's office. And whenever somebody wants to get money to use on behalf of the young child, they'll have to make a petition to the courts, about $50, for a filing fee, but it's still a pain in the tush. And then finally, at the age of 18, the children get everything, which doesn't make a lot of sense. I mean, I'm 63 now, but I remember what I was like when I was 18, 20 years old. If I'd got a lot of money when I was that old, there'd probably be a golden calf on the front of my fraternity's lawn to this day.
Yeah.
So a lot of times what people do is when you have younger children, you want to make sure that your beneficiary designation is positioned so that it actually would go into a trust for the benefit of young children to make sure they have money while they're growing up and available to them to use on their own when they're old enough to appreciate the value of a dollar. So these are sort of some of the things that can go awry.
How often do you recommend people review these designations? Because it sounds like a lot of bad can happen if things aren't right at the time of death.
Yeah, you're 100% right, Kevin. Basically, I recommend that the designations get reviewed whenever you review your estate planning. The rule of thumb is maybe from the time you're 25, 30 on, you should have your wills and or trusts evaluated. And parcel of that is having beneficiary designations as well as the ownership of accounts reviewed. A lot of times people think their account's just in their name, but they forgot they put a child's name on it. I've had people, I'd say probably about 20, 25% of the time, when somebody lists their assets on an intake form when they come to see me, when I ask them to produce the underlying documentation like the bank statements or the insurance designation forms, what they thought they had was something different reflected on the forms. So the rule of thumb basically is when you're relatively young, say up to the age of 60, 65, you ought to have that reviewed at least every 5 years. I think once you get over 65, 70, it should be like every 3. Because I will tell you quite frequently, people will set up everything properly, but I've had cases where I had a spouse followed by a trust for the benefit of children, be the beneficiaries of retirement assets and insurance. But then what happens is a couple of years after I've set everything up, they move their IRA from company A to company B. And when they fill out the beneficiary form, they don't think what they had with company A. They just automatically knee-jerk reaction, put the names of the kids in again. And so a lot of times I thought years ago when I got out of law school and started doing this, that I should be making sure that the estate planning documents were still relevant. But I found in just as many occasions, I'm glad you brought this up, that sometimes the documents are still great after 3 to 5 years in the review. However, somebody's made they've made a mistake when they've had to redesignate stuff.
Yeah, that's something that you want to get right. Like I said, I think that's probably good. 3 to 5 years. That makes sense to me. How do payable on death or transfer on death accounts affect the executor's job?
They don't. So just like with the other, so basically for all 3 of the non-probate categories of assets, the ones that pass by operation of law, that is the joint accounts, the contract assets, and the paid on death or transfer on death, they all pass outside of probate. And the only thing you typically need in order to have those assets transferred to you directly is a death certificate. So like Kevin, if I was to name you as the beneficiary of the IRA, you don't have to wait for my executor to turn around and say, Kevin, come and get it. All you have to do is go to the financial institution that holds the IRA and say, my dear friend Thomas passed away. Here's the copy of his death certificate, and they'll sit down with you and complete the necessary paperwork, have it rolled directly into your name.
You feel free to name me. I'm not opposed to that, Tom.
All right, that's fine. I'll be the best interviewee ever, right?
Yeah, that would put you at top. Yes, definitely. What happens if a beneficiary dies before the account owner and no alternate is listed? Does that asset then go through probate after all?
Yes, and that have been a bit of an issue. I have had a case where I've had to go to court for a retirement plan. Basically, a husband designated his wife to be the beneficiary, but he didn't name a backup. And as a result, it defaults to the estate. So there's a couple problems with that. The main is that when you're leaving, if you have children as the beneficiaries, if the IRA is left directly to them, they can defer the payment of the tax on the IRA for 10 years after death, as long as they take out the minimum distributions that they're supposed to do. Under a trust, wherever the trust or the estate's the beneficiary, well, if trust can have, let's go, the estate's the beneficiary, that 10-year period is reduced to 5 years. And also, that's if the executor holds on to the management for that 5 years. So if I'm the executor in a estate, or I turn around and the beneficiaries say, look, I want to manage my own money, I can give it to them now, but they're going to have to pay all the tax in year 1. And that's something to be spread over year 5. So it's real important to make sure that you keep an eye once again on the designations. Now, having said that, I've had a lot of success in court over the years through what's called reformation. So if somebody messes something up, I've often been able to make a petition to the local probate court and state on what's called the doctrine of probable intent, that if the person had realized the ramifications of not having a beneficiary, like instead of the estate, then they would have certainly named their children rather than let it default to the estate. And it does cost a little bit of money to get it set up, but typically the savings, either from a tax perspective or another perspective, is worth it. But of course, it's better not to spend a few $1,000s to correct something. It's better to do it correct the first time.
Right. Can non-probate assets create unequal inheritances with members if the will and the account titles and all that stuff don't match up?
Yeah, the most recent one I had was about 3 years ago. Mom had 3 children. She was widowed, and she had all these accounts, which at the time, I didn't do the planning, but my understanding, they were each worth a couple $100,000 when she established each of them. The problem is one had a lot of bonds in it, some had some stocks in it, and it's a different, one's just kind of pure mutual fund. And when she died a handful of years after setting them up, there were all sorts of, different, and some was like the stock was much greater than the ones that had the bonds because of the years that this happened. So I remember the biggest case I had was probably about 25 years ago. A gentleman set up $400,000 each for one count stocks of $400,000 to his son, $400,000 to his daughter in bonds. And years later, he died. The son's account was worth $900,000. The daughter's account was worth $500,000. It started out the same. So yeah, that's a disaster when people do that. So, and there's no reason to do it. A lot of times people keep hearing that you have to do things like that because of probate being so awful. If you and I were sitting in sunny Florida or California, I'd say absolutely. We need to do something as far as planning. That's not the plan we would do, but you'd have to do something. But as we've discussed before, Kevin, probate in New Jersey is extraordinarily easy. So to reiterate what I said in other episodes, when somebody dies in the state of New Jersey, the executor merely goes to the surrogate's court with the will, a death certificate, and a filing fee of about $150, $200 tops, and voila, that's pretty much probate. So there's no reason to do all what I call the craziness with the assets.
Yes, it's funny because I feel like probate is like a scary word for a lot of people, and maybe in some states, to your point, it is a more scary word. But what I'm hearing is that in New Jersey, it's not that anything. It's not something to be truly afraid of, except for there's a little bit of a cost, obviously.
Yeah. So yeah, and New Jersey has the easiest probate state by far. I mean, if you want to go back historically, one of the big issues is that we have a lot of people that become snowbirds as they get older, and they spend half their time in Florida during the winters, but they recognize if they spend an extra day over 6 months, they can qualify as Florida residents. And the nice thing about being a Florida resident, you don't have to pay any state income tax. In New Jersey, you still have to pay a pretty hefty income tax. It's one of the highest rates in the country. So people do that, but we do have much, much easier probate, I guess is something to balance it out. But obviously, that's not a reason to decide where you're going to live or not. But we do have very easy probate. So people should be running around doing unnecessary work and creating unnecessary hardship for themselves and, unfortunately, eventually their heirs.
Are there any other non-probate assets we haven't discussed that you feel people should know about?
I think we've pretty much hit the nail on the head. I mean, the only thing you can pass outside of probate is, you pass things through a trust. And I guess probably if you have non-probate assets, it's not necessarily bad to have them pass outside of probate in one particular scenario. And that is, let's say, once again, it's mom and dad, and they have 4 children. The 4 children are all responsible, and they're all up in, their 40s and 50s. They're all grown up, And in that particular case, sure, it's okay that when both of them pass, those assets go outright to those children. But when you have either a child who has got special needs, or in the alternative, you have young children, or you have a fair amount of money, we want to set up a bloodline trust, which I guess will be the topic of another episode. Basically, you want to name that particular trust as the beneficiary rather than the children, because what you can do is you can make a planning opportunity out of non-probate assets, because you can change the beneficiaries or the POD beneficiaries or TOD beneficiaries, and even how we're going to do things with joint accounts, so that you can position them to pass through the estate or into the trust which you want them to flow into.
Yeah, I was curious about that with joint accounts. So that best thing is put those in the trust?
Yeah, you put them in trust, or but even lifetime. Sometimes all you just do is you just get rid of if you get rid of the joint ownership. Now, one thing I've done, because people oftentimes will not get around to fixing things before they might see me again. Years ago, I created an equalization clause. And what it basically says is, before an executor, if it's a will or a trustee under a living trust, divides everything among the heirs, he or she is supposed to take a look at what the heirs may have received outside of probate. So, say, for example, you're one of 4 beneficiaries of my estate. Let's say I've got $800,000. So normally you'd be entitled to $200,000. But you got an account outside of probate that was worth $150,000. Well, when it's time to divvy everything up, you'll only get $50,000 from my estate, and everybody else would get $200,000 to equalize things. So it's something you can draft to minimize exposure to inadvertent mistakes or omissions that people do.
Mm-hmm. Yeah, no, good things to understand. Probate versus non-probate, very, very important. And I always say it, this is why you need an attorney for all this stuff. That's it for today's episode of the Estate Blueprint with attorney Thomas D. Begley III. To learn more about Tom's work in estate planning, probate, and trust administration, visit begley3law.com. That's the number 3. You'll find resources to help you protect your assets and plan with confidence. Thanks for listening. Don't forget to subscribe, share, and leave a review so more South Jersey families can find the guidance that they need. Tom, always great chatting with you. Thanks so much.
Likewise. Have a good one.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.